Hey folks, welcome back to the Wikipedia world, and I am Abhinay Gupta. And today again we'll continue with the chapter The Prevention of Operation and Mismanagement. Right? So in the previous lecture I had given you a brief of this chapter, right? That the majority rule generally prevails. But the entire concept of this chapter is first to find out the exception to the majority rule, right? That means also to instill certain limitations on the majority rule. And how is it to be done, what is to be done, all the procedures and all those stuff will be taken care of in this chapter, right? So today, as in the previous lecture, we had seen the Faust versus Harbottle case, right, as to what happened in that case and why the entire thing has popped up, right? And that the prevention is backed up by the Companies Act 1956 and also the other common law, right? Today we'll see the exception under the common law. So what are the exceptions that have been provided already in the common law that takes a step ahead towards the prevention of such operation and mismanagement, towards avoidance of that majority rule basically, right? So if you ordinarily look at the situation, everywhere the majority rule prevails, right? So if you see the companies in the Companies Act, there's a majority rule, there's a resolution that is to be passed either in the board meeting or in the shareholders meeting or anything, right? And since the majority member are in advantageous position, they may at any point of time exploit the minorities, right? And they may also cause serious damage and injury to the company on the whole, right? They can be directors who have a majority share in the company also, and they misuse their power for their personal gain. These things can happen, right? Thus, to protect the minority interest, certain exceptions to the majority rule have been given in the common law, right? And we have jotted down point-wise what are those exceptions. So number one, ultra-wise and illegal act, right? So exception to the common law are the ultra-wise and illegal acts that has to be prevented, right? So the majority rule applies only where the act has been done irregularly and ratification is possible, right? That is where there is a problem, that something has been done wrong by the majority or something has been done by somebody and the majority backs it up by ratification, right? But if you know the illegal acts, they cannot be ratified. So if something wrong has been done, even the shareholders ratification will not help and will not prove it right for the company, right? So even if all the members they consent and they vote in favor of something which is not right, it will not be applicable. So such provisions are already there, right? So when the company proposes to enter into any illegal transaction, for example, right, I am a company XYZ and I pretend or I pose to enter into an illegal transaction. What safety I have if I try to find out a loophole is that if the company, right, if it decides by a special resolution to do something, the company can do. That doesn't mean that the company can get into an illegal activity as well, right? So if we go through to the interpretation of statute, right, we should not be misleading these. So if we go by the grammatical explanation of the same, that yes, if it is ratified by the majority of the shareholders or if a special resolution is passed, the company can do this, the company can do that. The company can also amend the article and stuff. That doesn't mean that you can insert anything and everything in the article, right? There is certain legalities and illegalities in place. So if something is illegal already, right, it's already declared illegal, you cannot make the company take up that act just because the SR would justify it, right? And an individual member, he also has the right to restrain the company from making any of these illegal activities, right? Now maybe there are two directors of the company, right, and the directors also hold the majority shares. And what do? Beyond a certain point, they increase the salary to the employees, and that to the favorable employees, maybe the relatives, the friends, themselves, or something like that, which is not correct, right? So any other individual can pop up and say that no, this is injustice. On the same band, you're giving different amount to different people, can raise up a case. right? Because those are ultra vires and illegal. That is not supposed to be done. So under the common law also, these things can be protested against, right? The second is the fraud on minority. Now this is where the wrong intention comes into play. When we talk about fraud, right? Fraud is an intentional act to deceive somebody. So when the majority, they already know that, okay, see, we have major power. And there are certain of these minorities who have these shares. Let's do one thing. Let's pass a special resolution that all their shares will be taken up. Do you think they can do that? No, they cannot. If that was the case, nobody would have held the minority shares. Why? Because till the time we are losing or the companies are growing, right? I have put in some money in the company. Company is using the money. And if the company grows exponentially someday, sorry, there is no industry that grows exponential, right? So if the company explodes one fine day, then what happens? The majority will take away their share to earn the profit, and they'll not be left with any hope, right? So in that case, if the majority are trying to compulsorily acquire the shares of the minority, right, then the minority has the right to charge against them, right? Because the law will not permit the minority to be compelled to sell their shares to the majority. So they can at any point of time raise that alarm to the court, right? Because understand, right, if there are 98% shares already with the majority and those 2%, those poor kids, right, they think, okay, let's do one thing, let's give them off the company, let's purchase their shares. They pass a special resolution, they amend the article, they do whatever they can do, and then they form a regulation or the rule in the company that, okay, the minority shares will be taken over, and they take up. What can the minority do? Cannot do anything. Has no right in the company. The only thing that minority can do is to go to the court and file a case against this. Right? Now, there's another situation as well. So there are majority shareholders in company A, and the same majority shareholders also hold majority shares in company B. Right? Now what do? They see that company A is anyways not going forward, and company B is very promising. That is already giving return. So let's do one thing. Let this company A go to win. Right? So let us shift all the assets from company A to company B. Let us shift all the revenues from company A to company B so that we have a lot more to take from company B and we'll wind up company A. And will not pay the creditors, will not do this, will not do that. Whatever can come up in their mind. Right? But that would be a loophole if we do not put a block on that. Right? So by their discretion, the majority cannot do that. Right? There already has been a case of Menier versus Hoop Polygraph. Right? Over there also what happened, the majority, they tried to put something in their pocket at the cost of the minority. And thus the minority was empowered to take action. And when the minority took the action, the case was in their favor and the majority were restrained from taking those actions. Right? They simply understand if we give on the blanket power to the majority can do anything. They simply can go ahead and pass on any resolution they want. They can change any rule, any article, any memorandum, anything. But do you think that is fair enough? Giving a blanket power to somebody? No. All the power that has to be bestowed upon somebody has to be restricted also. Right? So there has to be certain limitations and restrictions to the power of the majority rule as well. Okay? So if there is a fraud to the minority, they have the power to appeal and get it sorted. Wrongdoers in control. So what happens again? It goes back to a similar case. The wrongdoers, people who are not there for some good faith, right? They hold the majority share. And they try to manipulate the operations of the company in their favor so that they fill up their pockets. And the people who are serious about the company, who are trying to take the company ahead and working their sweat and blood out for the progress of the company, they feel cheated. Right? They are giving their sweat and blood to the company and somebody is taking undue advantage of the same. So what do? It's simple. They'll go ahead and file a suit against the company, right? Against the wrongdoers, and they can do that. Okay. Next, we see the breach of fiduciary duty. Now, do you know what the fiduciary duties are? This is the highest standard of care. So when we say that the directors and the promoters of the company, they have the fiduciary duty to the company, means those people have the responsibility to show or to offer the highest standard of care to the company. Right? So you know, right, the promoters of the company, they're not supposed to make secret profits. They'll be feeding in their funds, and then in the resolution they will decide what money has to be given back to them for the promotion of the company that they have spent. Right? But what if the promoters, they start making some secret profit and they start filling up their pockets? To the breach in that duty, right? And so there are provisions already laid down that will compel them to be accountable for the profits that they have made. Right? No promoter can just simply come in, float a company, make secret profits and move ahead. That secret profit making is illegal. You know that already, right? So a suit can be filed and they'll be caught and then they'll be chased. Right. Now, what benefits or what advantage can these promoters or directors who are initiating the company take? Right. For example, if I am building up a company, right, and I need a lot of land for that, for some industrial setup, what I do is I take the land on the company's name, I get a very good deal, and I take some portion of that for myself and sell it off at a higher rate. That is making secret profit. Right. I what I do is I have a lot of land. Why we take an example of land? Whatever it is, right? And I have to deal in certain things. What do I show is that the deal happened on a lower rate and the extra margin is in my pocket. So the deal had to happen at 1000 per unit. I said, no, we're not getting anything in the market. So 800 per unit is what I have set, and that is the maximum we are getting. But in reality, he was getting 1100 and 300 goes to the pocket of the promoter under the table. That is wrong, right? Because in that case, they are not caring about the company. They are caring about themselves. Right? So they are basically breaching their fiduciary duty because it is their duty. It is their duty to serve the company, to care for the company, to grow the company. Right? But what are they doing? Is they are utilizing a contract that belongs to the company for their personal gains and benefit. Right? They sell any property away to somebody at a gross undervalue. Now what do you think is the case of this undervalue? The only simple reason for this undervalue, if it's an exceptional undervalue apart from the market, then the only simple reason that we understand for this undervaluation of that property or that asset simply is the under the table exchange of money. You understand, right? You're mature enough to understand what is under the table exchange of money. Right? It's a very common phenomenon that we have been noticing in our day-to-day life. Although we are building up good control against that these days, trying to fight it a bit, but that is a general thing that has creeped into the society, difficult to fight with, right? So there are provisions open to go and appeal and file a suit against the same, right? Now we also see that in the common law there is a requirement of a special resolution at times. Now why is that so? This special resolution itself defies the rule of majority. Because as per the rule of majority, even the ordinary resolution is the rule of majority, right? So why do we take it to the super majority? Because we do not want that majority to take advantage of their position, right? So what it says is if there are, for example, somebody holds 51% of the shares of the company, they take advantage of their position, right? Even though the other 49% are going on the other direction, they'll say no, when we said because we are majority, will go in this direction. So you notice, right, when something is not in the due course of action, that does not generally pop up, we always mention that you will have to file or you'll have to pass a special resolution for the same. Why do you think is that done? It is because when we pass a special resolution, there are very high majority that come together on a common platform to take the decision. Right? So it is not along the borderline anytime. That okay, it's 50, 51, 52%. Right? It's a big margin gap. And that is how they plan the business ahead. Right? The last one we have is the violation of the right of the member, which we also say infringement of the right of the member. Right? So understand where there's something wrong which is done to the company. Right? The company shall be the aggrieved person, as we have seen in the Foss and Harbottle case. Right? So similarly, where there is a personal right of an individual that is hampered or that is disturbed or that is infringed or violated, then that person should be a aggrieved person, right? So that person should also be given the right to go ahead and file a suit. That person should be given a right to take action for the enforcement of such rights. So if certain rights are given to the company, right, those rights should also be given to the individual. So where the company is affected, the company files the suit. But where an individual is affected, the individual is also given the right to file a case against. Right? So these are basically some of the points in the common law that actually sets some limitation on the majority rule. That by the majority rule you cannot pass any ultra vires or illegal act. By the majority rule you cannot defraud the minority. By the majority rule the wrongdoers cannot take control. By the majority rule you cannot breach your fiduciary duty. By the majority rule you cannot pass anything. There are certain situations which are special in nature and have just popped up, so we don't need any kind of risk in that, right? So maybe people don't understand, but still, since they're majority, they pass it on. So in that case, a special resolution is needed. And if there's a violation of right of the member, then the member should be given the chance to appeal. Because if there is a violation in the right of the company gets the chance to appeal, right? So why not an individual? For the violation the right of the company, the individual cannot appeal, it's okay. But for the violation of the right of the individual should be allowed to complain. And that they're allowed. Right? That is what this entire exception is about. So are you getting the point? Are you getting what this where this chapter is heading to? Right? So this chapter basically shows you the difference that okay, there has been the majority rule prevailing all around in our law, but there are certain limitations to it. It is not bound free. It is not set free to do whatever it wants to do. There are limitations and restrictions, the checks and filters in place. Right? So in the common law, these were few examples of the checks. And now if you move on to understand the exceptions under the Companies Act. So common law we have seen. Now what are the exceptions that have been provided in the Companies Act so as to put a stop or restrict the power given to the majority? Right? That is something we need to understand. So first thing that we see over here is the variation of the class right. Right. So you know that when you get a share, right, there are certain rights that are attached to the share. And that may be varied by the consent of the members holding 3/4 of the issued share. Right? So if there is a particular category of share, right, that has been issued, then if 3/4 member who have been holding that particular class of share can vary the rights in that share. Right? And such variation can be made only if the provision for variation is contained in the memorandum or the article. So first of all, you have to have those clauses in your memorandum of association, in your article of association, right? And then there has to be 3/4 of the total population holding that share that can pass on a rule to change it, right? So such variation, if I say, is not prohibited, right, by the terms of the issue of shares of that class. But if you look at it, the holders which are less than 10% of the total share of the class who do not have any call over there, right? If you see what happens is there are majority people who are holding the shares. What they do is they try to change certain rights that those shares contain. But what about the minority who also hold the same class of share, but since they're minority, they don't have a say. Right? Do you think it is justifiable to do that? Right? So what does the rule in the Companies Act say is that the other members, if you are not less than 10%, right? Even the Companies Act do not go ahead and in this case and say even if one shareholder wants, please come and complain. No, 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 no. They put up a limit that at least 10% should be there who feel that okay, these conversions are not good. So 10% or more, if you are, then please you can come and you can apply to the court for the cancellation of such variation. Right? So this is provided by section 106 and 107 of the Companies Act. So these kind of provisions are also there, where the majority had been given the power to change or to get into a variation of the shares right. Right? If they're three-fourth, what they have to do, they have to amend the article and memorandum that they can do anyways by passing the resolution. So they amend the memorandum article, then they pass on a rule and they vary the share rights. So the court says, or the section 106, 107 says that if you find you're aggrieved, please collect 10% of your cases. Right? When your population exceeds 10%, go appeal to the court and that variation will be stopped. Right? Next also, if we see the case of amalgamation and reconstruction. When I say reconstruction, it can be external reconstruction, it can be internal reconstruction. But what we basically need to see is that the transferee company intends to acquire the share of the dissenting shareholders. It has been cases, right? So I was company A. What happened is company B acquires company A. And majority of the shareholders of company A are okay. Okay. My shares were worth 100, you're giving me 300, I'm okay with it. Right? And on the basis of those majority, what happened is the company was taken over. It was either amalgamated, right, or it was reconstructed, or there was a merger, whatever it was, right? But now what happened, there were minority shareholders as well who were holding the same share and they were not happy with the rate they were getting for the shares. Right? But now what happened, if you look into it, then the majority shareholders, they can say, right, that okay, we have decided you take over, man, no problem. Do you think it is allowed? As per the majority rule, yes, it will be allowed. When majority says okay, that means it's okay. But understand, if a minority doesn't want to give in their shares, the transferee company or the company who is taking over the share cannot compel the minority to sell their shares. Right? They can only give them a notice that okay, this is the rate I'm agreeing to give it to you. Either you sell it or respond in some time. If you don't, the deal is closed on my end as well. They cannot come up and force the minority. No, your company by majority had decided that you will sell me this share at this rate. Come on, sell it to me. Cannot, right? So even those kinds of advantages or those kinds of protection has also been given in the case of amalgamation and reconstruction as per section 395. Right? Now, investigation into the affairs of the company. Right? Now understand, there is a section 235, where you are allowed to apply for an investigation into the affairs of the company. Right? But there is a requisite number of members who are empowered to make their application. Right? And that application is made to the company law board. Right? So what they do is there has to be a certain requisite number of members. They put an application to the company law board that according to us, what we feel is that the company is not performing the way it should be performing. So we want an investigation to be carried on, right, to check the affairs of the company, whether they are operating the way they were supposed to operate. Right? And when the company law board gets the petition, thereupon the central government shall order investigation of the affairs of the company. Right? The investigators will go, they'll start investigating. Right? And then we talk about requisite members over here. Right? Even that has been defined in section 235. That in case the company has share capital, the requisite members will not be less than 200 or the members holding not less than 1/10 of the shares of the total voting power. Right? So more than 1/10 of the voting power if you have, you can go ahead and file an application to the CLB to get the company investigated. Right? And if you don't have that, if you don't have 10%, but you are 300 people, although minority, but 300 people. So if that limit of 200 is also crossed, you can still go ahead and file an application with all your signatures and approvals that to CLB that please, we want the affairs of the company to be investigated. And then the central government sends some investigators. Right? So all these provisions are available in the Companies Act. Next, prevention of oppression and mismanagement, the exact chapter that we are dealing. So all the sections from 397 to 408 takes into consideration to prevent the majority rule. Right? Over here also they say that if there are requisite number of members, right, then they can make an application to the company law board if the affairs of the company is being mismanaged. Right? Over there they don't think that the affair was going good. So they are ordered for investigation. But over here they know that it is being mismanaged or are conducted in a manner which is prejudicial to the public interest or oppressive to any member in both the scenario. Right? And then the company law board will make order whatever it feels necessary to justify the fact of the case. But over here the requisite number has an addition. Right? So the requisite number means either 100 members or 1/10 of the total member or 1/10 of the issued share capital of the company. Means in the third position we are seeing the value as per the share capital. In the first two we are seeing the number of members. If there are more than 1000 then 100 is okay. If there are less than 1000 then at least 1/10 has to be there. For example, if there are 600 members in the company, at least 60 has to be there, if not 100. Right? And if the company has no share capital, then 1/5 of the total number of members. And similar was the case into the investigation into the company's affair as well. If there is a company without share capital, 1/5 of the total number of shareholders. Right? Total number of members, I mean, sorry, if there's no share, how can they be shareholders? Come on. Right? Then there are some other statutory rights also that has been given. Now these statutory rights basically refer to the Companies Act 2013. Right? So they say that the requisite number of members have the right to call an extraordinary general meeting. Right? And this is given by section 100 of the Companies Act 2013. Further, there is an extra general meeting required, extraordinary general meeting. So general meeting, if you know, then only it is held. The extraordinary general meeting is held when something extraordinary pops up, or there's a requirement to hold a general meeting because we need the opinion of the management or of the members. Right? So they also say that there are requisite number. This is the baseline. Above this, you can anytime call a general meeting to get ahead with any scenario. Right? Then you also get get to circulate the resolution. Right? Whatever resolution has been taken up, it gets circulated. So again, requisite number of members have the right to circulate the resolution at the general meeting. That is section 111 of the Companies Act 2013. Right? If they want to demand a poll, again there is a requisite number who can demand a poll as per section 179. Right? Any member can apply to the central government. When I say any member, means any member. Right? They can apply to the central government to call an annual general meeting if default is made in holding the annual general meeting by the company. So if the company, they do not hold the annual general meeting in a year, right, then any member can appeal to the central government for the same. Right? And any member can apply to the company law board to call an extraordinary general meeting if defaults in holding extraordinary general meeting. So in the case of annual general meeting, it is the central government whom they approach. In case of an extraordinary general meeting, it is the company law board whom they approach. And if any member wants the company to be wounded up compulsorily, they can file a petition on just an equitable ground, and then it is on the court to decide whether the winding up will be taken forward or not. Right. So these are the exceptions that we have already noted in the common law, right? These 6, and in the company's law, these 5. So we know that okay, the majority rule also is very general in the law, but doesn't all the time take advantage of that. There have been limitations, checks and filters on place to help the minorities as well. Right? So you see the thank you slide. That means we have come to the end of the lecture, right? I hope this lecture was helpful for you. From the next lecture, we start with the core understanding of the sections, right? And get into the procedural aspect of the chapter as well. Okay? So I'll see you guys back in the next lecture. Until then, this is Abhinay Gupta signing off. Thank you and bye-bye.